No, it's Friday the 13th of September 2024. Supposed to be unlucky, I don't know. Now, I want to get this thing about the law out of the way so that anyone that wants it can have it, and there might be only 1 in 100 would bother with it. There are a lot of people taking judicial reviews in their own name, no lawyers or anything else, and there's a few things that might be helpful and it might not. If you don't want it, turn away. There's no point saying don't be talking about law because it's all corrupt. That's not what I'm here for to do. I'm here to tell you the mechanics of it. So if you have, if you're taking a judicial review, you have to know a few basic things. And the only judicial review that you can get away with it pushing your case is habeas corpus. Some lad called User, I think, posted there, I hope the wind isn't taking this, he posted there about habeas corpus being produced in the body of a dead animal. I was going to delete him, but that level of ignorance, I'd love if my subscribers and viewers would tackle those people and ask them what they mean and let them have someone other than me countering them. But in any event, so habeas corpus, once you bring in the man from the prison into the room, the judge has to investigate. And that's the only instance where a judge investigates a case. Otherwise, it's up to the other parties to put the case. The judge doesn't investigate at all. A very slight departure from that would have been the case down in Wexford where there was allegations of wind farm noise and the judge, a female judge, went down and listened to it. So that was a little departure, but it's rare enough. But that's an example. A judge can go out and view the scene, of course, now, and get the full picture. Now, the thing about it is, at one time there was no parliament. There was just a king. The king didn't have time for making laws, so he left it to judges, and judges made the law. In the criminal law, they itemised, there's a plane going overhead here. In the criminal law, he itemised some of the crimes and some of the civil law. So the rules the judges made were known as common law, and some of the crimes were murder, manslaughter, arson, which is setting fire to places, bigamy, burglary, housebreaking, and larceny. And there was sacrilege, I think, as well. There's some of the ones they itemised. They were felonies, and in some cases they were punishable by death. So they didn't want everything punishable by death, so they brought out a term called a misdemeanour, and they were less serious. Embezzlement, unlawful assembly, riot were some of those. They named a good few of them out. So you'll get them there on the internet. They were misdemeanours, and they were less severe, but they were still indictable. You were entitled to be tried by a jury. And then there was the magistrates' court, or the court of petty sessions, as they called it, for small stuff. Now that has grown in proportion, and the magistrate has a lot of jurisdiction. A lot of cases come under them, like drunken driving, driving without insurance would be examples. Having no name on your cart, the way back in the time of Patrick Pearse, you'd have to have your name on the horse's cart. I suppose fishing without a licence in certain circumstances would be one. Having a firearm without a certificate would be one. They're summary offences, and then there's some of them are hybrid offences which the state can choose, or the person can choose which one he wants. So we'll not go into that very much. But the judges made the law, and that was supported by the doctrine of precedent and a reporting system. The doctrine of precedent and a supporting system. So we'll give an example of it. Stealing was a crime and it was punishable by death, and then they went to hang some fella for stealing a dog, and the judge said no, stealing a dog is not going to be a felony because it's not right to hang someone for stealing a dog. But then after that, it was still a hangable offence if there was a collar on the dog. So this is an example of the judge is making laws to suit the circumstances. So it might be to do with a right of way, or it might be to do with a contract or something. So the law of contract in common law countries was designed by judges, and there has to be an offer, an acceptance, an intention to create legal relations. The offer has to be communicated, the acceptance has to be communicated, and there is the postal rule. And the postal rule was brought out in the time of Henry VIII. Once the parcel is placed in the letterbox, that's it, the contract is complete. So people talk about not getting letters. Once it's posted, if you post a letter to someone, that's why registered post is proof. It's the date you post it that it takes effect, not the date received. So in any event, the judges then, when they made a decision, it was sent off up. And if you were in the High Court, we'll say, and there was a case, I'm trying to think of something now, the judge might rule that the road is belonging to the council for repair and the bridges, but the land under the road belongs to the landowner adjoining it. The judge might make that ruling. Now, he might say because the roads were put in there, but the landowner holds the land. And if the road ceases to be a road and the local authorities no longer maintain it, it goes back to the possession of the landowner. Now, that might be the law of the High Court. And then that mightn't be challenged. And if that was never challenged and it was obeyed going on for years and years, it would become the law, because it's what they call forged on the anvil of reality, right? So, but then somebody else might say, that's nonsense, or some council might challenge that and bring it to the next court, the Court of Appeal, and they might rule differently. And then it might end up in the Supreme Court. And the Supreme Court might rule, as they did in that case, that the land under the road belongs to the landowner. And Lord Denning said about the first and second spit, we'd call it layer, that the bit of tar and the bit of gravel, that's the council's, but the land under that belongs to the landowner. So that's the law, but you have to force these things on them. Anyway, when that become the law, that become the doctrine of precedent, and that's set there. And the only way that can be changed would be by the government bringing in legislation. And if the government bring in legislation to take the land of the landowner under the road, they'd have to pay the landowner. They'd have to compensate the landowner for doing that. But that is actually the law. That's the English law. There was a case only 4 years ago involving that Lambert Council in England. And so that's a very good example of common law. Now, another very good example of common law in the criminal context is that the judges' rules of 1912, you'll get them online there. So this dictates, you see, the law is that a person who's suspect of a crime doesn't have to open his mouth. You cannot be convicted out of your own mouth. That went back to Magna Carta, where they said you can't get a lad there and keep baiting his head against the wall because you think he stole your lawnmower, and he finally admit he stole the lawnmower, because if you don't, he'll die. So you can't have that. So the law was you can't be convicted out of your own mouth. And so the judges brought out the judges' rules of 2012. You'll get them online. And one is that I just can't remember them all. There's no objection to a police officer asking and inquiring about the crime. But if he suspects the person committed the crime, he must caution him that he's not obliged to make any statement unless he wishes to do so. And if he does, it'll be taken down in writing and may be given in evidence. And then if he's arrested and he's in custody, he must be cautioned straight away. Now, you'll get the judges' rules 1912 online. There's a very good example of judge-made law. And that then will not be changed. The government will usually not change it, although they amended it a bit in England that you can, if you withhold something, it can be used against you. But by and large, that principle applies. So I don't see the judge-made law going for a long time. Now, there's a thing called the stare decisis. The highest court is the precedent. If the High Court rules on a particular case, like the land under the road, it generally will not unwind it. You'll not get them to change, but they have the authority to change, and that's, I think, known as stare decisis. They can change their view. The Supreme Court can change its view in Ireland, and the highest court in Britain, if there's a good reason. There has to be a good and compelling reason. The High Court could say, we think that law now is obsolete, we're going to change it to something else. Does that make sense? So that's the doctrine of precedent in the common law, and that's what is mixed. It's actually mixed then, because you have European law in Ireland, you don't have in Britain, and you have the constitution in Ireland, and you have a sort of a Magna Carta, or unwritten constitution in Britain. And then you have the law made by the Parliament, and it'll overrule the precedent. If there's a precedent there, it'll say in the Act, any rule of law whereby the land under the road is owned by the landowner is hereby repealed. And then they'll have to give them compensation. Do you understand that? So that's rarely done, and it's rarely done. But sometimes the Parliament will change it. So that's legislation. And I've explained how they can make a statutory instrument under that then, and the what do you call them, the professional bodies like the Law Society and all of these. Now, the thing about it is, don't confuse. There are certain regulators put in place by the DAW, like the financial regulator, doesn't work at all. It's a sham. The advertising regulator doesn't work at all. A scam. The Medical Association does a bit. The only regulator that does work is the Law Society. And the reason the Law Society works is that if you're a solicitor and you do wrong, you can be sued. And it's the Law Society has to charge insurance. So if you're a lawyer, as I understand it, that you have to pay a premium to the Law Society. And if you break the law, they can strike you off the list and they have to pay. But the result is they will try and investigate wrongdoing by lawyers as best they can. And I had one particular case and they did actually do something. Now, I can't say that in every case, and there'll be people posting underneath, no, you're wrong and all that. So now, have I explained the doctrine of precedent in law? Now, in my degree course, I debated this. What the lecturers were saying is that the judge can make law if there's no law there, if there's an absence of law. That if you didn't have that, you couldn't get a remedy. So you'd go into court on something where there's no legislation, and you say, Judge, this is grossly unfair. And under the doctrine, the airplanes are going mad today. They're going to Atlanta, they're going to Toronto, they're going to New York, JFK. Oh, they're going all over. And some of them are going to California, so the noise is unbelievable. But anyway, where was I? Where did I leave off? So you have that idea about it, about the sources of law, and how the doctrine of precedent is part of the common law. And it's also part of the doctrine of equity, because equity was the court of chancery, and that's how judges had to make law. One particular law that was made, now by the way, a precedent generally in England will be very persuasive on any other common law court. A precedent in America here might be persuasive if it went way up to the highest court. So a lot will depend on the strength of the precedent. If it was only a minor court, you wouldn't argue it. So it depends on the strength of the case. So if a case in the High Court, that case Harry Miller now, that case went very high. That will be persuasive in courts. It'll be binding on lower courts in Britain, the Harry Miller case, the judgment, but it'll only be persuasive on courts in other common law jurisdictions. But because it was so high up and argued so well, it will be persuasive. It would persuade a judge to some degree. Generally speaking, English precedents are still considered high quality. Now, there's one particular case I know of an Irish precedent being followed throughout the world. And that was, there is a rule of law of evidence that that two people involved in a crime. There's a law of evidence that a wife cannot give evidence against her husband, except in very rare cases. But two criminals committing a crime cannot give evidence against each other. The judge has to warn the jury and warn himself that it's unreliable for two thieves to give evidence against each other. So two boys break into your house, and then one of them turns for the state, and he says, oh, he did it all. He broke the windows and he done all. Well, the judge would have to say, well, he was in there as well. So that's very dicey to use that. Now, so these two old lads was driving their car down in County Clare in 1936. I think one of them was named Egan, and there was a very narrow bridge, and they decided they were more important. One was more important than the other. He had one fella was an undertaker and he had a big business. The other fella was a big farmer. He had cows, God almighty, that was something. And instead of one letting the other go, they ploughed on and they crashed into each other in the middle of the bridge. And when it came to court, they were brought to court by the guards for dangerous driving, and they pleaded that they couldn't give evidence against each other. They couldn't give evidence themselves against themselves because of the rule that you can't give evidence against yourself. But the other couldn't give evidence either because he was a co-conspirator. The judge couldn't take his evidence. But the judge in the Irish case ruled that road traffic cases and road traffic accidents were of a different nature to the ordinary co-conspirator, or you know what I mean, an ordinary accomplice, that the two lads in the car didn't know each other at all until they crashed into each other, and therefore you couldn't use that rule. And as a result, in a traffic accident, the other party, even though he's guilty, can give evidence against each other. Do you know what I mean? And that's I think it's Egan. It's 1936. But that is an Irish precedent that carries all over the English-speaking world. That is an accepted principle. One of the few that's there, and it makes perfect sense. And it'll keep there because you're never going to be able to change that. It's just the best of good common sense. Do you understand now in that? So I hope I've dealt goodly now with the good way with the doctrine of precedent and in how it works. So if you go into court there as a lay litigant, somebody going in there because they were shut down during the pandemic, you need at least to know the legislation and say, Judge, I'm looking for an equitable remedy. I want an injunction against the state to stop me travelling. Here is the reason. The Constitution says such a thing. Here is the law. What's the law of the Health Act of 1947? You'd need to read out the section of the Health Act, and then you'd want to look and see, was there any precedence on that? Was there a ruling on this? Because there was consumption long ago, and there was lots of things. So if you don't know that and you don't know where you're going, you can't expect the judge to do your research. And the judge will say, I haven't. You could go in and say, this is contrary to the Constitution. Now, the other party will then probably come along, they'll have lawyers to state and say, well, there's certain cases. Well, then you'd adjourn and you'd study those cases and you'd say, Judge, this is a different case. You might make the case that this is all over the country and that there isn't sufficient evidence, and you'd be into all of this sort of stuff. So you have to fight your case like that. You have to prosecute your case, except in habeas corpus. So I think I've made that clear. It's not for the faint-hearted. I did it, but I have a good knowledge of it. And at the very least, in the top of your application, you'd need to write, this is an equitable remedy. And you'd need to say what's taken under. Now, in criminal law, as I say, they're bringing in a concept. I saw somewhere where if you're convicted in England, you can be made pay a bit towards the prosecution. I don't think that's legal. It's not the case in Ireland. They have to prosecute you. You can fight your way. And this is why in all the rascalities going on, I do try to lure them into taking an action against me, but they know they won't, because I don't have to pay it, only myself, but I'd have a bit of knowledge of it and I'd know how to handle these cases and fight it right the whole way up. But then it's, as I say, taking a judicial review or even fighting a case could take me 20 days. So I'd have to be kind of prepared. So when I break the law, it'll be a trap to get them in there. And even then I mightn't win, but you'd have to go to the Supreme Court. Again, you'd want 30 days maybe to fight that. That's an awful lot. And you're up and down stamping documents and everything. So it's not for the faint-hearted, but I hope I've explained the basics of the doctrine of precedent under English law, and that extends to Canada, the United States, the Cayman Islands, all of Britain, Ireland, Australia, New Zealand, anywhere the British tramped about is English common law. Now, one of the areas where it's very strong is in the law of contract. I don't think any country has as good and as sensible a law of contract as the British common law. So essentially, it is very wise. Now, there is an act, the Sale of Goods and Supplies of Services Act, to strengthen it a bit, but the basics are still there. As they say, it's forged on the anvil of reality. There has to be an offer, there has to be an acceptance, there has to be an intention to create legal relations. The offer has to be communicated, and the acceptance has to be communicated. If the acceptance is by post, it takes place when posted. That's the London fire case. A house was on fire on a Saturday, and your man insured it on the Friday, and he posted the cheque off and the acceptance on the Friday. He put the letter in the post box, and she went up on Saturday, and the insurance company said they weren't liable because they didn't receive the money until the Monday, and they refused to insure it. The postal rule. And I see there some case, I'll not mention any cases. If anyone hears about it, they're complaining about the post. That's the postal rule. You need to know that. Now, if you didn't know that, if you went up to the High Court and you didn't know that rule, nobody's going to plead it for you. No one's going to accept it. You need to know that, but that's a crucial rule. The contract takes place the day it's posted. Now, the thing is, there's rules then about contracts about minors and people doing it when they're drunk, and you can't sign a contract except in certain circumstances, and if it's land, it has to be on paper, but if it's about a tractor, it doesn't. The court will infer from the result. And you know this earnest, you give them a £50 luck penny, that's just an earnest. That shows there's an intention to create legal relations, but it has no further thing than that. The shaking hands or the agreement is what counts, and it's communicated and all of that. So that's the common law at its best form, and that'll never be changed. That'll be in the waste in 500 years' time, because it's just so sensible. So absolutely sensible, and it just works so well that who would want to change it? You wouldn't be bothered. But it is amended a bit by various sales legislation and different type of things like that, and protections against minors and people who are maybe not too well in mentally and all of that. So, and then there's cooling off periods and things like that. That's legislation. So the legislation in that case will overrule the common law principle, but it doesn't just do away with it. It just fine tunes it and makes it a bit more equitable. That's it, folks, on 19 minutes. I hope that's a help. I didn't realise, but there are plenty. They're going mad up here over my head. Good luck. We'll see you back. Post underneath, but please don't say it's all a cod. It's all a cod. I'm trying to give you the law that I know about, and I have to say the law I'm giving you is my best advice, but I'm not your lawyer, and I can't be accountable or held liable for it. I will not take liability for some lawyer doing it down in Cork that I have no control over. I'm only giving you, as an ordinary listener, the law, and as to bring up your level of knowledge of the country you're in, so that watching my channel brings the benefit of becoming wiser and wiser in that way, and you become you get an idea, and in that way hopefully people will be more wise in the decisions they make in the polling box and in their appreciation of other things, and in that way I slowly but surely bring people around to my point of view. Good luck. We'll see you back for something else. Comment underneath, and don't be afraid to dig into somebody that's posting rubbish, because I don't like deleting anyone, Okay, bye.